Good morning, sir. Are you Christopher Stiles? And this is 25 DCCR 0594. Mr. Stiles was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge. State answers.
Is there any objections or explanations?
There's an explanation, Your Honor. There is a statement that's made under the defendant's version that I know would probably cause the court some concern. I would like to point out a couple of things. Number one, there was more discussion about that in his personal interview. I was present for that interview. That specific sentence was actually pulled from the questionnaire that was filled out prior to the interview. So there was more discussion. It wasn't just simply just that one statement. But what that relates to is, number one, if we go back to the beginning of this, in this case, he entered a plea of no contest. And I think he could probably address better exactly why he made that statement and why he's still wanting to move forward with the no contest plea. You have anything to say?
No, and that was one where y'all agreed to a no contest?
Correct.
Because I typically don't do that.
We agreed and the court was okay,
Okay.
at least at that time.
Okay, so then any issue going forward, Mr. Coleman?
I'm just very concerned about going forward, given what appears to be that lack of acceptance of responsibility, Judge. Saying to the effect that I don't feel I committed a crime gives me some concern.
No.
Well, I know there will be some mental health treatment, and because of that, and because of what you guys looked at ahead of time for that no contact, the no contest. Obviously, I was looking at also the contact issue, but I think I'm willing to go forward. What about the restitution? That it looks like there was a total restitution amount.
And I want to say everything looked correct, except for there was one. I believe the first item may have been a bill, not a pay, not a receipt. So I think that was the only question I had. I kind of forgot about that, but I'm not sure that was paid or not.
Well,
We don't contest it at all. It's just, I just don't know if that was incurred or if that was the original billed amount. But we're not opposed to that just being corrected at a later time.
the way it shows, it was no insurance payments or adjustments applied. So the patient balance was that $1,300. So if it's the patient's balance.
But the other ones had insurance deductions. There was insurance.
Right.
In place, so
Here's what I'll do. I can always just order in an amount not to exceed that total amount.
Yes.
And that way, if there's anything that comes up, he's responsible for it unless there's some proof to the probation department that that's been paid or reduced. Okay. All right, then, Mr. Stiles, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 5 years. You are ordered to pay $500 fine as well as restitution in the amount not to exceed $1,655.24. You're also to follow all of the rules and conditions of probation. That includes having only supervised contact with the victim in the case, that you will have a mental health evaluation and any type of treatment that is required. You will be ordered to do that, whether it's counseling, medication, whatever it is. It's now part of your probation, and all that's just meant to make it where you can be more successful in life and obviously on probation. If you do everything that you're supposed to on this probation, it's an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and you can go to state jail prison for between 6 months and up to 2 years. Do you understand?
Yes.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you, Judge.
Thank you. Morning, you're Austin Talbot,
Yes, ma'am.
and this is cause number 20-35335. Mr. Talbot is on probation for aggravated assault causing serious bodily injury. There's been a motion to revoke file. Mr. Dalmore, what is the announcement?
Judge, I believe we have a proposal for the court we would like the court to consider. Mr. Talbot would enter pleas of truth, and the agreement is that he would be extended for 1 year because his probation's already expired. He's already passed his expiration date, so he'd be extended for 1 year by agreement.
And that would be subsequent to an updated PSI, Your Honor, whatever terms and conditions you might think necessary. It was my intention that he enter a plea of truth to the Tyler County DWI so that the updated PSI could take those factors into account. I
Is there a court date set for
I don't
that?
believe
Not in
that
the
case
file.
has been resolved yet, so it'd be a little bit difficult for me to prove it up, but if he will enter a plea of truth and do an update, I'm not opposed to continuing him for some period of time before it agrees.
And that's obviously the main thing. There's also a large arrearage. Correct. I guess
He did get another job now. He lost his job, got another job in Newton County, right? Did you have to move to the Tyler County or Newton County?
No, I'm working in Angelina County.
Angelina County.
And I'm working for USA Lawn Services. That's the only place that would hire me.
So he believes he'll be able to knock off that arrearage.
Yes, ma'am. And
Okay.
I'm waiting on tax money too, so that would
so,
go
okay.
forward to pay it all.
Okay. I guess there must have been an issue, obviously early on, with some alcohol issues, and you went through the ATAR program.
Yes, ma'am.
And so it looks like you were supposed to have a court-ordered interlock device on a
Yes.
vehicle.
I have,
But part of this is that he left, not just didn't have one, but all that happened in Tyler without that as well, which obviously gives me concern. Do you have that on your vehicle at this
but I
time?
don't drive. I have a breathalyzer thing that I carry.
Okay.
Person.
Okay.
I blow 4 times a day.
Okay. And you're not driving?
No, ma'am.
Okay. And it looks like you signed some time ago a note that you would not drive with probation, correct?
Yes, ma'am.
Okay. So then I guess let's go through the motion today and we'll reset it for sentencing. Let me get that pulled up. Mr. Talbot, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And will he waive the formal reading of the motion?
Will, Your Honor.
So, again, in clause number 20-35335, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 22nd of 2021 for the offense of aggravated assault causing serious bodily injury, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes.
And it alleges that you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated, second on May 20th of 2025 in Tyler County, Texas. And is that true or not true?
Yes, Your Honor.
Thank you. Count 2 alleges that you failed to remain in Jefferson County, Texas, as you were ordered, and that you were in Tyler County on May 20th of 2025 without permission. Is that true or not true?
True, Your Honor.
Okay. You sound like you're not sure about that one. Did you have permission to be in Tyler County from probation?
No. Your Honor.
Okay.
That's good.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Yes, Your Honor.
True.
True. Sorry.
Count 4 alleges that you failed to abstain from the use of alcohol and that on May 20th of 2025, you were arrested for driving while intoxicated in Tyler. Is that true or not true? Count 5 alleges that you're behind in your court assessed fees as of January 13th, 2026 in the amount of $4,357. Is that true or not true?
True.
Count 6 alleges that you violated the court-ordered interlock device by operating a vehicle on May 20th of 2025 that did not have that device on it. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, Your Honor.
And because those counts are actually true. All right, then I'm going to find that you entered your pleas of true to 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. However, I'm going to reset your case for sentencing so that the probation department can do an updated report, and then we'll come back with the notation that it is the agreement to extend probation by 1 year, and then I'll look at any other conditions based on that report, I guess, that might be necessary.
That's our understanding, Your Honor.
Okay, if you'll just stop and talk to probation at the desk over there on your way out, we'll see you back at sentencing.
Judge, I'm sorry, may I just add a couple things while we're here?
Yeah, wait, y'all wait just a second. Go ahead, ma'am.
Judge, I handled this case originally, and would you please just admonish the complainant, there have been no issues, thankfully, in probation to my knowledge, to continue because his probation has expired and we haven't yet extended it out technically, would you please admonish him to continue that no contact with the underlying complainant, Amy Barnado, and also just so the court is aware, a lot of times those fees look like they're owed to probation. In this case, it was a subrogation issue and they are owed to an insurance.
Okay. So obviously because the motion is pending, even though the time has run, you're technically still on probation because the motion holds it open. So you're still on probation, same conditions apply that you've been on, as the no contact and trying to get that money paid as quickly as possible.
Yes, Your Honor.
Okay. Yes.
Can,
You can ask me questions over here.
okay, okay.
And if y'all need anything, just let me know.
Okay, thank you, Judge.
Thank you. Morning. Are you Clayton Friddle?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Will, Judge. Sorry for the terrible handwriting.
So what is the reduction to?
It's not a reduction, Judge. It's a principal oppression.
Oh, yeah. Okay. That's why you'll have to
So-
do it this way. Got
I'm
it.
sorry,
Yes,
there's not
ma'am.
a paper for that one.
There's not, but that's perfect the way you did it. Thank you.
Just remember that you said that was perfect.
This one's,
This one, just this one time.
it's on the record. All right, Mr. Friddle, in clause number 25 DCCR 0450, you're charged with a class A misdemeanor of official oppression from December 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
And then in clause number 25 DCCR 0451, you're also charged with a class A misdemeanor of official oppression from March 3rd of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
It's just, sorry. Looks like the agreement that you've reached in each of your cases is for a 1-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, and the state will file a dismissal in cause number 25 DCCR 0452. Is that your understanding?
Yes, Your Honor.
State tenders number 1. I'm sorry. Do you, are you also a U.S. citizen?
Yes, Your Honor.
State tenders number 1 in each case?
No objections, Judge.
It's admitted in each case. Is there any evidence that Mr. Friddle is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered those pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In cause number 25 DCCR 0450, find sufficient evidence to find you guilty. However, I'm going to follow that agreement, defer all proceedings, place you on probation. For 1 year, you're ordered to pay the $500 fine and again to follow all of the rules and conditions of probation.
Yes, Your Honor.
In cause number 25 DCCR 0451, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings and place you on probation for 1 year. You're ordered to pay a $500 fine in that case as well and to follow all of the rules and conditions of probation. If you do everything correctly on probation, this is an excellent opportunity because you do not have convictions on your record. And at the end of the probation period, if you successfully complete the probations, then the 2 cases will actually be dismissed. You'll never have the convictions. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and you could be sent to the Jefferson County Jail for up to 1 year in each of those cases. Do you understand?
Yes, Your Honor.
I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when they're ready to go over your paperwork.
Thank you.
Good luck to you, sir. And good morning. Are you Richard Vullery? And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Let's see, are we going on count 1 only?
Yes, Your Honor.
All right, Mr. Vullery, in cause number 25, DCCR 1746, the state has elected to proceed on count 1 only. You're charged with aggravated assault with a deadly weapon from October 21st of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
I do.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And so it looks like there's an agreement for deferred probation. Is there an amount of time? I don't see it.
It's up to the court. Your Honor.
So the agreement is for you to have a deferred probation. The fine and the length of your probation would be up to the court and any other conditions. Is that your understanding?
Yes.
Also, you would be, part of your probation would be that you have no contact with the victim. Is that your understanding as well?
And Judge, just to refresh the court's recollection on that and why I put any and all conditions in PSI, although of course that's always a condition for the court. We have heard a couple of times on bond issues with respect to contact orders and locations of employment between Mr. Vullery and the complainant, Mr. Collier. So I just wanted to put that in to make sure the court is aware when he comes back that that was an underlying issue. I have no reason to believe that there's been any issues since our last bond hearing. But I just wanted to.
And I've received some documentation since then about the store.
Correct.
This is the one with the store
Yes.
that they, okay. And I think that's all worked out,
Yeah,
correct?
yes.
Believe so.
Okay. It is obviously very important. You know, Mr. Vullery, we've talked about this before about the no contact. And if there's any issues with an employment and him being around there, you need to get with Mr. Lewis and probation between now and then. So we make sure we get that worked out. Okay.
Judge, meeting a gentleman?
Yes.
Oh, okay.
Also, do you understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm sorry.
I just understand.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vullery is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Thank you, Judge.
Good morning, sir. You're Joshua Barlow,
Yes, ma'am.
and this is 17-26688. Mr. Barlow's on probation for possession of a controlled substance. There's been a motion to revoke filed. What is the announcement?
Judge, I think we've come to an agreement with the state for us to that would allow Mr. Barlow to continue with his probation, also us resolve the issue of the case in Harris County. And I guess I don't know if we want to enter the pleas now or how do we want to handle that? Or we go back to court there on Thursday.
So I guess, is it agreed here?
Yes.
Judge, it's my understanding that those cases will not be prosecuted in Harris County. If we can receive confirmation of that on Thursday, I have no reason to doubt what Mr. Lewis has told me on that. and possibly extend Mr. Barlow. He's set to expire next year. If you refer to the original PSI, Judge, you will recognize his name from some other more egregious offenses that he was able to get out from under, so to speak. I would ask the court, if you feel like we have time today, we can drug test him today just to make sure he's negative today. And then we wanted to defer to you with respect to entering pleas or waiting to see what happens on Thursday. If we can maybe put it in a week or two, that might help us, but whatever you want.
Okay, let's make sure you're clean today. Mr. Barlow, have a seat in the jury box. We'll do that. And then, I guess probably easier to just reset it a couple of weeks and make sure that's gone. That way you can abandon them instead of him pleading not true, whatever. Let's do it that way.
Okay.
Typically I'd say let's take the pleas, but let's wait since it's just this week.
Okay.
But let's do this first.
Okay.
And let's see, Alyssa Bush. Morning. Are you Alyssa Bush?
Yes, ma'am.
Thank you for filling that in on the front page.
If it's for the court's information, the state's offer and the agreement of the parties reflect the fact that the defendant has paid full restitution up front.
Thank you. And so what we're going on is what?
Lesser included of
Attempted. Okay. And will your client waive the formal reading of the indictment?
She does, yeah.
Ms. Bush, in cause number 25, DCCR 1754, the state has elected to proceed on the lesser included offense of a Class A misdemeanor of attempted credit or debit card abuse from September 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $250 fine. It sounds like restitution has already been paid, so that won't be an issue. And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Bush is not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you satisfactorily complete it, the case will actually be dismissed and you'll never have the conviction. The other side of that, though, is if you violate your probation in any way, you can be brought back into court. You can be found guilty of the offense and sent to the Jefferson County Jail for up to 1 year. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Excuse me. If you'll just have a seat here in the courtroom, probation's going to call you to her desk when she's ready to go over your paperwork. And she's sitting at that desk right over there. So just watch for her to call your name. All right. Good luck to you, ma'am.
Thank you.
Thanks, Judge.
Thanks, Judge.
Good morning, ma'am. Are you Treasurer Harris?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She does, Judge.
Ms. Harris, in cause number 24, DCCR 1482, you're charged with a 3rd-degree felony offense of unlawful carrying a prohibited weapon, and that's from March 28th of 2024. And how do you plead to that charge?
Guilty.
I'm sorry, not guilty.
Guilty. Sorry.
Did you do it or did you not do it?
Guilty.
Okay. Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. You would be ordered to forfeit the weapon, and also that you could not go, you'd be trespassed warned from any of the Lamar University residence halls. Is that your understanding of the agreement?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Harris is not competent?
No, Judge.
Right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right over there. All right, we'll see you back at sentencing.
Sorry, so no, my handwriting looks worse than kindergarten on there. That pen kind of gets away.
It does. Same for mine.
Anyway.
That's Devontre Johnson. Good morning. Are you Devontre Johnson? And this is 25 DCCR 0438. Mr. Johnson's charged with failure to comply with sex offender registration requirements. And what is the announcement?
Just Mr. Johnson has provided me with information from the officer he was initially reporting to in Louisiana before this case was filed. And it's at least mitigating at best. And I would like a chance to follow up with that so we can get a short setting
Sure.
so I can do that.
Okay, we'll just probably do a normal reset, maybe 3 weeks. And so, Mr. Johnson, if there's anything else that's important, make sure you get that to Mr. Lewis so that he has plenty of time to go over that with the assistant district attorney. And then we'll get an announcement at the next court
And
date.
Judge, I would like to know the state has made a new offer to us this morning, so we'll need time to, go over that with
Okay,
Mr. Johnson.
make sure you make an appointment, go visit with Mr. Lewis before that next court date. All right, you're free to go.
Okay, thanks, Judge.
Thank you. Richard Volry. Good morning, sir. Are you Remington Boykin?
Yes, ma'am.
This is 25 DCCR 0396, and Mr. Boykin is charged with tampering with governmental record. And what is the announcement?
Judge, I'm going to ask for one more short normal resetting, 29 days or something like that.
Short, normal.
Short normal. I'm trying to come up with an agreement that everybody can work with. It's unlikely to be a trial, so I don't want to.
All right. Looks like you subbed in September of last year. This will be the last reset. So, Mr. Boykin, make sure you stay in touch with Mr. Bird so you guys can visit about the case, and we'll get it taken care of one way or the other the next court date. All right. You're free to go. You're Blake down again? Blaine, I'm sorry. And this is 25 DCCR 0566. Mr. Dunnigan's charged with driving while intoxicated, third or more. And what is the announcement?
Judge, Mr. Smith has made an offer in the case. I've conveyed it to Mr. Dunnigan. We are attempting to try to renegotiate the offer with some additional information about Mr. Dunnigan to Mr. Smith. So I'd ask for one more resetting to see if we can get that done. I think this is only our.
You've been on since October of last year. So this will be the final reset in this one as well. Make sure you stay in touch with Mr. Birds, get any information to him. Y'all visit before the next court date, visit with Mr. Smith, and then we'll get it taken care of at the next court date. All right, you're free to go.
Judge.
Good morning. Are you Eric Landry?
Yes, ma'am.
And this is 25 DCCR 1238. Mr. Landry is charged with failure to comply with sex offender registration requirements. And what is the announcement?
Judge, this I think is our first appearance. We're asking for a resetting on this.
You were hired in October of last year.
Okay.
So
Either way,
Okay.
we've got an offer from Ms. French. I've talked to him about it. We are going to attempt to make a counteroffer, we think. But
I'll do, we did a long reset for some reason in January. I don't know if it was, anyway, there's been quite some time. So this will be the last reset in this one as well. So we'll do, Mr. Landry, make sure you stay in touch with Mr. Birds before that next court date so you guys can visit and we'll get your case taken care of at that day. All right, you're free to go. Are you Miguel Martinez? And this is 25 DCCR 0584. Mr. Martinez is charged with aggravated sexual assault of a child. And what is the announcement?
Judge, Ms. French informed me this morning that they provided us some additional discovery. Is that
I think your office requested media
Yeah.
and the media was provided on Friday.
on Friday? So we're asking for some time to get that reviewed.
Okay. This is, this one's been since June of last year, so this is going to be the final reset on that one as well. Get that, sounds like it's been provided. Mr. Martinez, you need to make an appointment, go visit with Mr. Gertz. Y'all can go over everything because we'll need an announcement at the next court date. All right, you're free to go. Shay Morgan, Shay Morgan. And this is 24 DCCR 2102. Ms. Morgan's charged with theft of property. What is the announcement?
Judge, we've got a deal worked out for restitution in exchange for a dismissal. We've got 95% of the restitution that I've given Ms. Malfino this morning. There's a remaining amount that we're going to pay via our trust account later this week, and Ms. Malfino has agreed that if we do that by Friday, she will file a dismissal with the court.
With the court's permission, Judge, they have tendered $12,000 today.
Okay, today was the last reset. So I'm going to reset it to next week, get that taken care of this week. If it's dismissed, then nobody has to come back. Otherwise, we'll need to do something next week. So make sure you get with Mr. Gertz. You'll get that worked out this week.
Get that money paid and then.
Okay,
You're free to go.
yes, ma'am.
Thank you. And I'll send that dismissal, Judge, as soon as I have that.
Okay, thank you.